The topic of capital gains tax, or CGT, in relation to trusts is undeniably intricate and can lead to considerable confusion. Many individuals, perhaps like you, may not fully grasp how these two areas overlap and what implications that could bring. As you might have heard, even the great Einstein once remarked that understanding tax law is a formidable challenge. By diving into some essential points today, we can shed light on this complicated subject and help you navigate through the bewildering interaction of CGT and trusts. Firstly, if you hold your home in a trust, it's crucial to know that you cannot access the CGT main residence exemption. This situation arises no matter what type of trust you're involved with, except in the case of a special disability trust. For many people, their home is one of their most significant assets, and losing this exemption can lead to substantial financial consequences when considering the sale of the property or any transfers. Moreover, transferring assets to a trust or declaring a trust over an asset always triggers CGT implications. This effect is similar to the tax consequences of selling an asset to a third party. It's essential to realize that whenever you are involved in asset transfers related to trusts, you may inadvertently incur CGT obligations. Be cautious, because failing to address these tax implications correctly can lead to unexpected liabilities. Another key aspect is the special rules that apply when trust arrangements involve life and remainder interests. In these cases, the asset is owned by a trust for a beneficiary while they are alive, such as a surviving spouse. Upon the beneficiary's death, the asset ownership reverts to the remainder men, typically children. Understanding these rights and obligations can be complex, but it's vital for determining how CGT applies in these situations. In addition, if an asset is moved from a trust to a beneficiary, both the trustee and the beneficiary face CGT consequences. These stipulations are clearly outlined in CGT legislation. It's worth noting that when an asset is held absolutely for a beneficiary, the actions of the trust regarding that asset are deemed to be those of the beneficiary. Determining whether you indeed have such a trust can be a complex task, complicating your understanding of your potential liabilities. Lastly, the situation surrounding inherited assets becomes even more nuanced when a person passes away. When administering an estate, understanding the rules that govern inherited family homes, especially concerning tax-free capital gains, is vital. Furthermore, if a family trust makes a capital gain from any dealings with CGT assets and wishes to distribute that gain to a beneficiary without losing its tax character, you must adhere to very complex guidelines. Given the intricate nature of these rules, it is strongly advisable to seek professional assistance. Understanding the nuances of CGT and trusts is a task far beyond what an average person, even one as brilliant as Einstein, could easily navigate without expertise. Don't hesitate to reach out if you need help interpreting these complexities. We are here to guide you through.